CRJ 230, this is the guide for week number 13. Week number 13, we're going to look at document evidence, which you can take to mean good old-fashioned paper, or pretty much anything that you create electronically as well. The same parameters, the same expectations are going to hold true there. We're going to get into the Brady rule a little bit, and you may have heard of the Brady rule, and you'll definitely know what it's about when we get done with this section. That's part of your reading. There's a short article that I linked to Blackboard as well as the Brady versus Maryland case. If you haven't read those two items, please go back and read those items now before you continue to listen. And then you're going to look for an Illinois case. Same parameters as all semester long, but the Illinois case has to be a criminal case, and it has to discuss and include an issue regarding an alleged Brady rule violation. So every entity, every company, every government agency, every organization, every person makes and keeps records about themselves and about other persons. Criminal justice entities are no different from other organizations in keeping records. So the police agencies, prosecutors, every area of the criminal justice system, criminals keep records. When these records are sought to be part of a criminal trial and introduced into evidence, they have to be authenticated. And we've talked about authentication and how we authenticate any evidence when we try to introduce it at trial. There's a whole bunch of evidence that gets introduced as a writing or a document. And it's a little different from the written format. They have to be treated somewhat differently when a party wants to introduce the evidence into court. Written documents constitute an important portion of evidence considered by triers of fact. So your report that you create electronically, we're going to consider that a document. Okay, the report from the person at the lab that does the lab analysis, even though that's an electronic thing, it can be printed. We're going to consider that a document for our purposes here. If it is, in fact, a piece of paper created document, then we have to show that it's genuine. Well, we still have those same expectations for any sort of record or document. Documentary evidence considered by a court and jury in reaching a decision may include a traditional writing. It can be video, it can be audio, it can be a record on a computer, a hard drive, in the cloud, on a document stored on a thumb drive, your phone, any device that can hold a record. It could include a printout from a computer. But that might bring out the opposing party's argument about best evidence, if you remember our best evidence rule. The general requirements of relevance, materiality, competency we discussed in prior weeks relating to opinion testimony and the hearsay rules apply to document evidence. It applies to all evidence. It applies to document evidence, as well as you know, oral testimony. However, there are some tests that are peculiar to documentary evidence, and if you did the reading, you know what those rules are, especially those related to authentication and the best evidence rule. Evidence isn't admissible until it's authenticated. Document evidence is no different. This means that competent evidence must be introduced to show that the document, the writing, the record, the tape, the video, the recording, it's genuine. It's what it purports to be. A handwritten document must be authenticated before it can be considered for admission into evidence. Now, we don't deal with handwritten documents a whole heck of a lot. But just as an example of how that would have worked, or how it will work on those occasions when you get that, it's not a lot different than how we authenticate many other things. In order to authenticate a handwritten document, the party who's offering the document can have the person who has sufficient familiarity with the handwriting of the purported author. Doesn't have to be the purported author. Just somebody who says, that's, John's signature, that's John's handwriting. And they offer that opinion, and it's an opinion concerning the identity of the author of the document. In some instances, authenticity is taken as sufficiently established for purposes of admissibility without extrinsic evidence to that effect. Now, this is known as self-authentication. In order to introduce a 911 call recording, as an example, it must first be authenticated as being the genuine recording. To authenticate that 911 recording, the party offering the audio tape as evidence could have the person who called 911 listen to the tape and identify her voice or his voice as the voice that made the emergency recording. They could also have the dispatcher, the person who took the 911 call. As I record this, the George Floyd murder trial is going on. Those things are happening right before your eyes, live. So you can see that sort of authentication and what's self-authenticating. Official records made by a public officer who has the duty to keep records of transactions, those are ordinarily admissible in evidence even though not verified by the person who actually made the entries. A lot of times those entries may have been made a long, long time ago, and that person who made the entries is no longer even alive, let alone available. But it was an official record, so there are those types of rules. The rule of evidence that requires the contents of an available written document to be proven by introduction of the document itself is known as the best evidence rule. The best evidence rule generally requires the production of the original writing unless the offering party demonstrates a proper excuse for failure to present that original at trial. Now keep in mind, if the writing qualifies as a duplicate original, it may be admitted as if it were the original writing as long as it's been properly authenticated or stipulated to by the parties. A lot of document evidence, the parties stipulate. So the parties agree that you don't have to bring in the original, this copy's okay, and there's a whole stack of copies. And by that point, they've all either seen the original, know the original exists, but have accepted the fact that the copies that they've been tossing back and forth in discovery are in fact true copies of that document. So it's not the authenticity of the actual original. What they're really worried about is the content, and they've agreed that the copies demonstrate the content of that document. In some instances, when documentary evidence is voluminous, we may even allow summaries. If it's shown that the summary accurately summarizes the material involved and does not refer to information not contained in the original. And again, that's going to be most likely with the stipulation. Now, Brady. The Brady rule is named after the case Brady versus Maryland, a 1963 Supreme Court case that dictates that prosecutors must disclose materially exculpatory evidence. If that materially exculpatory evidence is in the government's possession. If it is, they have to give that evidence or allow that evidence to be viewed, tested, seen, known by the defense attorney. Brady material or evidence the prosecutor is required to disclose under this rule includes evidence favorable to the accused, evidence that goes towards negating a defendant's guilt, things that would reduce a defendant's potential sentence, or evidence relevant to the credibility of any witness. If that's counterintuitive to you at this point of this class or your studies, I want you to stop for a minute and think about that and why does it feel counterintuitive, because it shouldn't be, okay? I'll say it again. Brady requires that the prosecutor disclose evidence that's favorable to the accused, that goes towards negating a defendant's guilt, that would reduce a defendant's potential sentence, or evidence relevant to the credibility of any witness. So in other words, if the prosecution knows there's a witness that is not credible or has a credibility issue, they have to disclose that evidence. Now, the reason I made that statement just before I repeated that line, that information, this is a pursuit of the truth. Justice is a pursuit of the truth. It's not about winning. It's not about losing. It's about justice, about finding the truth. And whether it's a criminal case or a civil case, both sides have a duty to disclose all facts, all evidence, anything relevant, whether it's harmful to your case or helpful to your case. There's kind of this attitude of you got to win that creeps up in a lot of different areas of life. Win at all costs. Not here. And when you see people get in trouble, it's because, and when I say people, I mean prosecutors, police, people that work in this area, it's because they don't honor that fact. They don't honor that oath that they took to uphold the law and to act and work in that manner. And so they may fail to do some of these things, even though they know most likely that they're supposed to. If the prosecution doesn't disclose materially exculpable evidence, and the defendant can show prejudice, as a result, the evidence will be suppressed. The evidence will be suppressed regardless of whether the prosecutor knew the evidence was in his or her possession. So forgetting that you had the item or the information is not an excuse, or whether or not the prosecutor intentionally or negligently withheld the evidence from the defense. So in other words, going off my little warning about making sure we know why we're here in this area of the law and why we're here in these career fields, intentionally, absolutely, get out and I'll run you out of the career. And you'll probably be in a pickle at some point. You'll be in a situation where you might be facing criminal charges. But sometimes the volume of things you have in a case is so large that it's potentially possible that you could forget that you had this item. It could be overlooked. It was without intention. What this is saying is, doesn't matter. Doesn't matter that you meant to do it or didn't mean to do it. It doesn't matter at all. If you were careless, it's still going to be held against you. Now, cases that follow Brady saw the Supreme Court eliminate the requirement for the defendant to have requested the favorable information because that was the excuse. Well, you didn't ask for it. I used to face this in civil cases all the time. Get some lawyer from one of the huge civil defense firms. So, well, you didn't ask for that. Well, I won't say the word that just came to my mind. I don't have to ask for it. I ask in general. That's as specific as I need to be. You're withholding things from me that you're supposed to provide. So the Supreme Court kind of followed that. I mean, it goes along with our canons of ethics and how we're supposed to practice law, and they stated the prosecution has a constitutional duty to disclose. It's triggered by the potential impact of favorable but undisclosed evidence. It's not dependent on whether they asked for it. So if you have it, you have to disclose it. If the defendant, or it's the defendant who bears the burden to prove that the undisclosed evidence was both material and favorable to the prosecution. In other words, the defendant must prove that there's a reasonable probability that the outcome of the trial would have been different had the evidence been disclosed by the prosecutor. Now, reasonable probability is not beyond a reasonable doubt. And so if something's so glaring or egregious that it, in a reasonable person's mind, and it's going to be the judge who's hearing the motion, in that person's mind, this is something that would have swayed the reasonable juror or judge, you're going to win. Should have been disclosed. In your chosen professions, you're either going to create or rely on documents, statements, and reports every day. If you're charged with creating these documents, remember that you may also be called to testify about the contents of those documents, or reports, records, recordings, right? And that means you might be cross-examined on anything related to your efforts at producing those documents. So be diligent, be accurate. Make sure you have the document reviewed by someone else. A lot of cases it's going to be reviewed by your supervisor, but don't just pass the buck thinking that they're going to spend a lot of time on it. You make sure you spend a lot of time on it. Make sure that it is as good as you can get it. Maybe have a coworker take a look at it before you give it to your supervisor, and then make sure they sign off on it. And if they think there's anything that needs to be address it immediately before the document's finalized. If you're reviewing these sorts of reports as a paralegal, be sure to do so critically. Look for mistakes, questions or issues, things that raise a concern. Things that are related to you or your assignment in the case that you're working on. Now, I mentioned discovery, and we've talked about discovery before. Discovery is an all-encompassing term to mean anything that must be disclosed to the defense by the prosecution and vice versa. In civil cases, we have the same thing. Anything that has to be disclosed by the plaintiff to the defendant to the plaintiff. Examples of things the defense would see are a list of witnesses in the nature of their testimony, police reports, lab results, a list of physical evidence that the state will seek to introduce, etc., and etc. All the things that the prosecution has. Basically, discovery helps the defense lawyer assess the strength or weaknesses of the state's case. Discovery is an ongoing process by the police or by the prosecution and the defense counsel during the criminal process. And the state has a duty under the Brady rule to disclose any evidence at any time that might show the defendant is innocent. Now, you might think that, and a lot of people do think, that when somebody is taken into custody that the police have all the evidence. Now that's it. And then they move on to the next case, and that's not true. Having done our discussions on circumstantial evidence, they may have enough to connect the dots and enough for the prosecution to charge or seek a grand jury indictment. It may be very clear, but they're going to still keep looking for evidence. And as they look for that evidence, what this is saying is, so if they turn up something that's not favorable to them in that continued effort, they have to turn it over. They have to let the defense know. If they turn up anything new, anything that evolves up until the time of trial, and including during trial, has to be disclosed. It's an ongoing process during the criminal process, and the state has a duty under Brady to disclose any evidence at any time that might show the defendant is innocent. The defense must also provide discovery to the state in much the same way, including providing notice of any affirmative defenses, like self-defense. If they intend to pursue an affirmative defense, and I mentioned self-defense because that's the one that's probably going to come up the most, the defense doesn't have to tell the state how it's going to present that defense, only that it may present it. The defense can list alternatives, and they don't have to pursue any of those, but they do have to, if they're going to pursue those, they have to give the prosecution notice ahead of time. So again, I'm assuming you read what I had linked. The article's short. The Brady case is relevant to the rest of your career. It's once again a week that brings together the 12 weeks prior to this week. So don't be afraid to go back and reread Brady. Be sure to take your time in writing out your case example and focus in on the facts and issues related to the alleged Brady violation or allegation of a Brady violation. And go and read your fellow classmates' cases, because you should see a spectrum of different types of violations or cases, and it'll be really good and something that you really need to grasp in this area. This doctrine, the Brady doctrine, is something that you need to know. This is the guide for week number 13. Only 3 more to go. Stay well.